Better still, in a living trust, I can do things like benefit adult children. Right? I've got kids who are 23 and 21, neither of whom are completely financially independent, but they are adults. And if I was incapacitated, and a guardian was appointed for me by the court, that guardian could not help those kids financially with my assets. It's legally prohibited from doing it. But in my trust, I could tell my trustee, well, as long as I'm taken care of, or maybe as long as me and my spouse are taken care of, and there's enough money to take care of us in the reasonable future, then trustee, I'm going to at least give you the power to help those kids financially if they need it, if there's an emergency and they need help. So I can give those kinds of instructions to the trustee, much broader than in just a last will and testament or in other kinds of planning. It's private, right? Your trust agreement does not become part of the public record like a will does. When I open a probate estate, the way I do that is by filing an original will with the court. Then I have to report to the court what this person owned, what it was worth, who's going to inherit it, when they're going to inherit it. That's all public record with a last will and testament. In a trust, I don't have any of those obligations. It's private between me, my trustee, and whoever's going to inherit. And generally, it's good in every state. My will, as long as it's valid in the state it's created, is going to be valid in other states, just like my trust is. The thing you have to keep in mind, if you move out of state or are from a state other than Arizona, it's those ancillary things, the powers of attorney, the medical directives. Those are the things that tend to be really state-specific. Not so much the last will and testament or the trust. So you always should, by the way, review those things if you moved out of state or come from a different state. So why, I talked a little bit earlier about some of the protections that you can have in a trust plan versus just leaving assets outright. So what are those kinds of things? Well, let's say I have a living trust and it says, well, upon my death, divide my trust assets between my 3 kids and just give them their share. They're all adults, right? They're all 20s, 30s, 40s, however old they are, but they're adults. I just give them their inheritance and now it's theirs. Versus I give them their inheritance in trust. So I say, son, here's your 1/3 of that inheritance, and it goes into the son trust. And it stays there for your lifetime, son. You, son, can become the trustee of that trust, so you control your own inheritance. Right, so each of my 3 kids can become their own trustee of their own trust share. They control it completely. But as long as it's inside that trust, it's not really theirs. It's your assets that you've left for their benefit. And the benefit of that is nobody else can get to it. Right? It's protected against their creditors. It's protected against their predators, like the daughter-in-law or the son-in-law that I never much liked anyway. Right? They're going to get divorced. Well, I don't want them ending up with half of what I leave my son or daughter. Well, I can protect against that by leaving the inheritance in trust. Maybe I need to protect the beneficiary from themselves. Maybe I've got a child that's an alcoholic or a drug addict or has other developmental issues where I need to protect the beneficiary themselves from themselves. Well, I can leave the inheritance in trust and just make somebody else the trustee. And then also for estate tax protection. Right? If I've got a child, and we'll talk a little more detail about the estate tax issue in a few minutes, but if I've got a child that has money, has a potential estate tax problem, and I just leave them assets outright free of trust, well, those assets are now part of their estate for tax purposes. If I leave it to them in trust, as long as I do a couple of things I can talk about, it's not part of their estate for tax purposes. Right? So I've protected that second level of tax. I've at least ensured that what we own as a family is not going to be taxed at each generation. We can at least skip one generation at my child level. So lots of reasons why I might leave it in trust.